Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, law made simple. Here's your hosts, Sam and Gina Ventola.
I'm Gina.
And I'm Sam.
And welcome to Sam the Answer Man podcast. Now I have to tell you fans that I'm representing my favorite college football team today. Of course, the significance of the red indicates the University of Alabama Crimson Tide, Roll Tide. But the jacket, the houndstooth on this, represents the greatest coach in college history.
And
believe me.
And she just loves to rub it in that I went to the University of Colorado when college football season comes along. But that's all right. We get along anyway.
Well, speaking of contentious type matters, let's talk about litigation.
Okay.
So I hear this all the time. Someone will come up to me and say, hey, Gina, I have this problem. Someone's made me mad. Can I sue him for it? So what do I tell him? Well, I don't tell him anything because I'm not an attorney. I say, talk to him.
Technically, anybody can sue anybody for anything or for no reason at all. A lawsuit is created by the filing of what's called a complaint. And once that complaint is filed, nobody checks to see if it's good enough at the very beginning. So once that's filed, yes, theoretically, the lawsuit is created. However, how far it gets is another issue.
So they don't even check for what's called standing, right? Like that you are the right person to be suing, right?
Normally not. I mean, the federal courts actually will test certain jurisdictional things at the very beginning, but that's sort of the exception. And you have to look, when you talk about litigation, you have to talk about what court you're talking about. So for the most part, there's four basic places that somebody might file a lawsuit. One is small claims court, and that's a court where you just file your lawsuit. The other side comes in to respond, and you have a trial that day. Lawyers are not allowed, and you simply argue your case before the judge, and the judge enters a ruling, and that's it. And it's designed to keep the costs very low. In Colorado, the amount of controversy has to be under $7,500. But that's the quickest and cheapest way of filing a case if you file a small claims court. One step up from that is called county court, and that's can only apply to cases that are worth $15,000 or less. And in those cases, sometimes lawyers are allowed, but oftentimes it's meant to be simple enough that people can do it themselves without a lawyer. And there are a lot of cases in county court. Eviction cases are typically heard in county court. And again, it's not quite as fast as small claims court. You do have to come back for a later trial, but the procedures are very much streamlined and it's designed to be low cost and doable for people who are not attorneys. Then the next level is either in state or federal court, what's called district court. And that has unlimited jurisdiction, and there the procedures are much more cumbersome. Really, you would be very hard pressed to do it if you were not an attorney to try to do it yourself. And the cases go on for a long time, and they're a lot more expensive.
And the trial date's like a year out, right?
Typically in both state, Colorado and federal court, they try to set the cases within a year. And so the initial trial date is normally set within a year. One thing, you have to understand about the court process is that judges can always change things, and they frequently do for the convenience of the court. And so even though in state or federal court you receive a trial date that says your case is going to go to trial on this date, the courts will actually have set several different cases to be tried at the same time. If all of them go to trial, they can't all be set at the same time. And the court will simply tell some of the people, okay, we're continuing your case is going to have to be heard later. And they very often don't tell you that. I've had cases where they didn't tell us that until the day of trial. And so, again, the court is very conscious of preserving public resources and its own resources, doesn't really care too much about the litigants or the attorneys. And so even though you spend all the time, maybe you brought in witnesses from out of state, et cetera, you may find out when the case goes to trial that it's going to get continued. But at least initially, the cases are typically set within 1 year. That's the goal that they have.
So let's back up a little bit. So we've talked about basically the long view of litigation from time the suit is filed into trial.
Right.
What happens in between?
So I'm going to be talking, I won't be talking about county court cases or small claims cases because that's not typically the cases that we do. But,
yeah, because they could, I mean, Judge Judy's an excellent example of, I would think, small claims court.
Right. That's People's Court, Judge Judy. That's meant to sort of replicate small claims court process. Our cases are the district court cases that go on for a long time. So the first thing that happens after the complaint is filed is generally you have 21 days to file an answer. And no matter what level of court you're talking about, the most important thing I can tell anybody involved in the litigation process is do not fail to file an answer. Do not fail to respond to the complaint. So many times I see clients come to me and say, I have this problem, I was sued, I didn't really do anything about it, now this judgment. After a judgment is issued against you, it's going to be very, very difficult for you to contend that it shouldn't have been issued. And you will have waived a lot of your defenses, maybe all of them. So it is absolutely essential that you do something to get an answer in if you are sued, no matter whether it be small claims, county, district, or federal court. So having said that, so after the answer is filed, the courts expect the attorneys to sort of work on what the discovery process would be. And discovery is a term that we use for the process of getting information before trial.
Like evidence.
Evidence, right. And you, of course, will already have probably some evidence already, but this is your opportunity to try to get evidence from the other side or from other sources. So typically this involves what we call written discovery, which are like interrogatories or requests for production.
That's a big word right there.
So interrogatories are written questions that you can send to the other side, and they have 35 days to respond, and they'll answer all of your questions. Hopefully.
Under oath.
Under oath. However, the limitation of the interrogatory process is really it's the lawyers answering them, and some lawyers are very slippery, and they'll do everything they can to prevent you from getting a comprehensible answer out of these interrogatory questions. But they have some use. And then request for production, you can say, give me all your documents of this category. And again, you know, you'll get a response back in 35 days. Sometimes it's very obtuse, but hopefully you'll get documents that you need from the other side that way. This is all what's called part of the discovery conference process. And what the attorneys do in the beginning of part of the case is they decide what that process is going to look like. How many interrogatories are we going to be able to have? How many requests for production? That kind of thing. And
requests for production would be like documents.
Typically, but you can ask for production of physical things as well, or for entry on land. So another aspect of discovery is depositions or subpoenas. So depositions can be either of the other party or of third parties. If you're a third party, you can go serve them with what's called a subpoena and have them produce documents or have them show up for deposition. And you can also bring the other party in for deposition. And we did a tape on depositions.
Yes, we did a podcast on depositions.
You know, there's more there about what that process involved, but basically it involves people having to come into usually an attorney's office, court reporters there, and questions are asked. And that's deemed more useful than interrogatories sometimes, just because, you know, if they're giving you squirrely answers, you can follow up and try to get the answers you want. So anyway, in the initial process, the attorneys are coming to an agreement or taking positions as to how many depositions should be allowed, what kind of written discovery should be allowed. And then within a month or so after the case the answer has been filed, the court will have a conference where they bring the attorneys in. There are a couple judges that make the clients come in, and you have a conference about, okay, what are we going to allow in terms of discovery? Then you have a delay of 8 or 9 months or so where you're doing discovery and then getting ready for trial. In that process, a lot of courts require parties to go to mediation.
I like that.
We also have tapes about mediation. Typically, people don't do that until the end of the process, very close to court, very close to trial. As we've said in our other tape, there are reasons why you might want to do that sooner than that. But in a lot of courts, you're required to go to mediation at some point. There's also the possibility of filing of written motions. And typically, they're like what's called a motion for summary judgment. A motion for
What in the world is that?
Yeah, a motion for summary judgment is basically a motion to the court that says, under the law, no matter what the disputed facts are, I win. So you have to basically say, even if the other side is telling the truth, I still win. Now, if the other side says, something outlandish, but they have their own testimony establishing it, that'll probably preclude you from being able to get summary judgment. But if this dispute is simply a legal one, or if the other side has completely been unable to obtain evidence to support its position, you may be able to get a motion for summary judgment. And that's a motion you can file basically at any time during the case process, as long as it's not too close to trial, to say to the judge, basically dismiss this case. There's also something called a motion to dismiss that's very similar. It's basically, under the law, the case should be dismissed. It can't stand up. So those are motions that can be filed in certain cases if there's not disputed facts that prevent them.
Okay. So can we do kind of a real life example of this? Let's say I'm in a car accident and I sue the person behind me. Now, do I sue the person or do I sue their insurance company?
Well, that's a good question. So in a case of a personal injury, people think that they're suing their insurance company. You're actually not. You're actually technically suing the other person, and it's the other person who you have to serve with the lawsuit, not the insurance company. And there's an exception to that for car accidents where you can serve the insurance company on behalf of the named insured, on behalf of the other driver, if you can't find them. But generally, you're supposed to serve the other driver, not the insurance company. However, the insurance company will then be notified by the other driver. They'll come in, they'll hire a lawyer and defend it, but it's always in the name of the other driver. And it's kind of a funny sort of theater kind of thing, in the sense that the whole process involves sort of pretending that it's the other driver who's defending it, and you're not supposed to talk about the fact that there's insurance involved, even though it is, and probably most of the jurors know that there is.
Now you're talking about serving. Okay, so what papers are being served and who's serving them?
So when you file a complaint, the case doesn't start until you serve that complaint. So you can't do it yourself. The person who's a party to the case can't serve it, but you can get a process server or a sheriff, or anybody who's not a party to the case can go to the place where that person lives or wherever you can find them, and hand them the complaint and a couple other documents that are filed with the complaint, and serve them in that way.
And so, as you said, then that's when the 21 days rolls.
Right.
That they have to respond. And if they don't respond, what happens?
You get what's called a default judgment, which basically says, I served this, they didn't respond, I get judgment. And again, a default judgment eliminates all defenses. Basically, they get everything they're asking for, and you don't have any ability to defend it.
And that's why you say that's the worst position to take, is to do nothing.
Right. Never, never, ever let the answer deadline slip.
Always respond. Okay, so the driver responds. He says, I slammed on my brakes, and that's what caused the accident. What happens after that?
So presumably you say you didn't. And so that's a kind of a factual dispute that's going to preclude any kind of motion to dismiss or summary judgment. Basically, that's something that the jury has to decide. Now, a case is decided by a jury most cases are decided by a jury if either side had asked for a jury. And one thing I have to remind clients of is, even though you have to pay an extra fee to ask for a jury, I always advise them it's a good idea to do it. A lot of times the clients don't want to do it, but then I've had clients down the road get mad at the judge for some ruling or something and say, I want a jury. And it's like, you can't now. You have to make the jury demand at the very beginning. So it's always a good idea to go ahead and do that, in case you get mad about something later on at the judge. But anyway, so that's a case that's going to have to be decided by the jury. So there will be case management conference. There will be arguments by the lawyers about what discovery should be allowed. Then the court will issue what's called a case management order, making a ruling as to what discovery will be allowed. Then you'll have interrogatories. You'll have depositions. You might have experts. So another thing that happens is in a lot of cases is parties will say, okay, here are the experts that I'm going to bring, and here are their reports. Here's what they're going to say. And then there might be depositions of the experts. There might be depositions of the parties. Sometimes they are. Sometimes the case is small enough that people don't bother to take depositions of the experts or even the parties.
So all that's done, and we're gearing up for trial.
Right.
And we take it to the jury. And the jury renders a verdict.
Right.
A judge renders a ruling. So there is no jury ruling and there's no judge's
Technically, the
verdict.
word verdict only applies if it's a jury. Judge will issue findings and conclusions, it's often called. If it's the case is to be decided by a jury, they issue a verdict. Otherwise, the judge will issue a ruling. And in a case where a jury has issued a verdict, a judge may still issue a ruling. A judge may say, well, there wasn't a basis for the jury to do that, so I'm going to order a new trial, or I'm going to order judgment for the other party, just depending on what the facts are and what the law says about that situation. So there's a lot of complexity to it. It's part of the reason why it's very difficult for somebody to by themselves represent themselves in a district court case.
So what you're saying is if you need to sue someone or feel the need to sue someone, they should come talk to you.
Yes. Or
if you have received papers being sued, they should talk to you.
Definitely, before the answer, definitely.
So there you have it. Sam has written a great article on this, on the whole litigation process, and it's on our website in the bottom right corner under recent blogs. And we have others. You can look on our podcast. We have another podcast pertaining to just depositions that can give you some valuable information that we didn't really go into detail here because we went into detail there. But either way, if you have any questions, email Sam at samventola.com. That is the best way to reach him. And to reach us, you can see us on YouTube. Subscribe to our Sam the Answer Man YouTube channel. We're also on Facebook. You can go out and like our Facebook page and get more information that way. Get maybe some exclusive content. That's kind of fun. And secondly, we're on other social media channels, such as I mentioned YouTube. So YouTube and LinkedIn and Instagram. Yeah, we post a lot of these little clips from these podcasts on Instagram, so you can follow us there. So we are everywhere, and that's not even mentioning the audio ones.
Right.
We have Anchor and Stitcher and iTunes. You can find us. We are everywhere. So check us out, and thanks for listening or watching. We love our fans. Thank you so much for your support.
Bye-bye.
Bye.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.